This is Nick Thompson in Louisville, Kentucky, a bankruptcy and foreclosure lawyer. What are the non-dischargeable debts that you can't bankrupt? Well, first of all, right off the bat are the obvious ones we think about, such as alimony and child support. No, you can't discharge alimony and child support. And generally, if there's an issue such as collection in state court, or there happens to be an issue of how much child support or alimony should be, the bankruptcy court will allow that case in state court to go on. However, believe it or not, child support or alimony are priority debts. If you wanted to pay back those debts to make sure that they got preferential treatment and that your alimony and child support was taken care of, you can actually add that into a Chapter 13, and you can ensure that other debts, such as your credit card debts, got paid very little, and the very first debts to get paid were alimony and child support. These are priority debts. There's a difference between priority, secured, administrative, and unsecured debt. Unsecured debt should be paid last. Administrative debt and priority debt are paid first, and after administrative and priority debt becomes the unsecured debt. So if you're wanting to make sure that child support and alimony is paid, you can funnel your finances through the bankruptcy court, and you can actually make sure that alimony and child support is paid ahead of everything else, and that the very last of the money ends up going to your unsecured debt. This is rarely done, but it certainly can be done in bankruptcy court. You're not discharging, you're not getting rid of the alimony or the child support debt, but it is a priority debt, and you need to recognize exactly what it is. What other debts are non-dischargeable? Income taxes, for instance, are not dischargeable generally until they're 3 years old. But after they're 3 years old, they can be discharged if you filed taxes on time and followed all the rules. And you can see our other video about specifically step by step what it takes to discharge income tax debts. Most attorneys, or a lot of attorneys, will assume that income taxes are not dischargeable when they actually are. The idea is that you take income tax debt and you move it from being a priority debt, where it's less than 3 years old and it has to be paid in full, over to an unsecured debt because it's over 3 years old and it's not secured. Sometimes, if the IRS has attached your house, then that becomes a secured debt, and that is paid back to the extent that the claim is secured in your Chapter 13. And priority debts and secured debts must be repaid, or at least brought up to date, according to one section of the code, which is 11 USC 1325. Okay. Many of the debts that you think of that can't be discharged or gotten rid of by bankruptcy are actually dischargeable under limited exceptions, or there are rules that allow us to manage those things. Well, can you do with student loans? Student loans can be discharged. About 500 to 1,000 people every year end up discharging their federal government student loans or private student loans. What happens is it may be that paying back the student loans would cause an undue hardship to you or your dependents. And if it would deny you food, shelter, clothing, or medical care, because the student loans would take away so much money that you couldn't meet the necessities of life. And you have tried in the past to pay your student loans. You're unable, you may or may not have been able to, but you gave it your best efforts. You currently cannot pay it back, and you never will be able to pay it back looking forward into a reasonable period of time, then you probably fall into that classification. what you want to do is you want to take a look at that. Don't assume that just because of the fact that it's a student loan that it's not dischargeable. There are also other exceptions to student loans. And you can look at our website, go through what we've written about, and see what some of these exceptions are, because every year, 500 to 1,000 people end up getting the hardship discharge for student loans. And even if you can't get the hardship discharge, you can at least perhaps make these student loans manageable. Okay. You can have different things that you can do with the private student loans, such as running the statute of limitations. Some states have as little as a 3 or a 5 year statute of limitations. And just by not paying the student loan for 3 or 5 years, you may end up running that statute of limitations out and actually discharging the private student loans. Also, debts due to fraud are not dischargeable. If you ended up stealing from your employer, criminal restitution is not dischargeable. There are a number of debts that are not dischargeable, but all of these debts generally are something that you're going to say to yourself, well, of course I can't discharge that one. Just because the government overpaid Social Security benefits to you does not mean that it's not dischargeable. You can discharge that as well. And quite often, the best thing that you can do is sit down with a bankruptcy attorney, somebody who's experienced and knowledgeable, and ask them, hey, can I manage this in a bankruptcy, or can I end up discharging it in a bankruptcy? This is Nick Thompson in Louisville, Kentucky. We're happy to give you a free 2-hour consultation. We'll be happy to sit down and go over these things with you. There's information on our website, and there's our manual on how to manage and bankrupt income tax debts and other debts that you thought probably were non-dischargeable. Give us a call. Pick up the phone. Thanks.